Dr. Oscar Schiappa Pietra. He is a member and executive director of the Binational Plan in the Peru chapter. He is member of the Peruvian Society in International Law. Professor Ana Salinas de Frías, ad hoc judge for the European Court of Human Rights and president at AEPDIRI. Professor Aiko Nakai, he is an associate professor at the Osaka Metropolitan University and member of the Japanese Society of International Law. Professor Pablo Martínez Rodríguez, he is professor of International Law and European Law at the University of Granada. Professor Shinji Sawada, he is a member of the National Defense Academy of Japan. And Professor Isabel Recabarren, who directs the Center for Studies for the UEALC. She is a doctor in international law and economic, and she has coordinated 2 legislations in the for the Parliament, for the Eurolat Parliament. Without further ado, we give the floor to the chairman.
Well, thank you very much. Just to go straight to the point, I guess the reflections we are about to share this morning cannot be more timely in a context in which democratic values, democratic rules, and democratic governance are suffering a very significant regression, both at the global scale and at the national level. And we are facing a scenario in which we are simply witnessing what is happening, and we are still not being able to provide responses to this democratic crisis. I personally have been studying in the last years about the global constitutionalism, and I have reached a point in which I have started questioning the relevance of such an exercise in considering that we are facing a process of very significant fragmentation in the international scenario and of huge polarization. So, well, without further ado, our first speaker will be Professor Ana Salinas de Frías. Professor Ana Salinas, please go ahead. Thank you.
Hello?
Yes, please go ahead. Adelante, por favor.
Hello?
Sí, le escuchamos. Adelante, we hear you. Sí, ya, adelante, por favor, la escuchamos. No, no la estamos escuchando. Shit. Sorry. Un momentito, por favor. Sí. Usted está probablemente en muted. Sí. Usted está silenciada en su computadora. Ahora sí le escuchamos. Adelante, por favor.
De acuerdo, perfecto. Thank you very much. Before starting, I would like to invest 2 first minutes to thank the organizer for this kind invitation they have done to the Spanish Society of International Law, and allow me to do it in our beautiful common language, the Spanish. Muchísimas gracias por esta invitación a la Asociación de Profesores de Derecho Española, de Derecho Internacional y Relaciones Internacionales, de la que me enorgullece ser presidenta, y en nombre de todos ellos les agradezco la invitación a participar en esta mesa redonda y la pena por no haber podido participar en persona, tanto el profesor Martín Rodríguez como yo misma. Thank you very much, and I will go straight to the point because I know we have just few time. The international system uses continuously, since the end of the 20th century till nowadays, uses continuously the term rule of law and democracy. And it has been used, for instance, by international leaders, international organizations. I think now of the refundation of the NATO, for instance, the funding values of the European Union, of course, of the Council of Europe, etc. Terms as protection of human rights, democracy, of the rule of law are used. Sometimes it seems to be used in an equivalent manner. Of course, they are not exactly the same, and perhaps many authors, perhaps because many authors so establish or so assume the rule of law is the more comprehensive principle of these three main concepts, so subsuming the two previous ones, the protection of human rights and also democracy. At the same time, the use of the term governance is gaining space, is gaining room, and a central role also at the international level and also within the international legal system being more and more used, together with this idea of a constitutional system. We have even celebrated the UN International Year of the Rule of Law, and the aspirational governing principle of the international society, either at the political level, but also at the international legal level. International legal order must constantly defend and reassert its foundational elements against internal and external threats or doubts or attacks. Some claim that during the past decade, the contestations have ascended to a new level and may challenge the core integrity of the international legal order. I would like to make here 3 points. First, it is possible to identify some foundational elements of international law that can be generally accepted by all states. Second, can such core elements reach a normative threshold to be considered requirements rather than values or just virtues? Third, and finally, what are these core requirements of the international rule of law? Challenges now facing the world are to be overcome, among other elements, obviously, by the means of rules internationally agreed, internationally implemented, and, if necessary, internationally enforced. That is what the rule of law as it stands at the domestic legal systems would advise, and requires also, it seems, at the international order. We will discuss over that. Because, however, the rule of law has been considered as sort of a blank term that appears to be overused, of limited analytic value, rather a descriptive value, and potentially distorting. The international rule of law has not developed into a vacuum. Its conceptual roots, practices, and reflections in judicial decisions inevitably draw from the notion of the rule of law at the internal level. Nevertheless, the domestic rule of law concept cannot be simply transposed, implemented, or internalized by the international legal system. For very well-known reasons, the horizontal hierarchy of actors, in the case of the international arena, the decentralized lawmaking, the lack of effective judicial review mechanisms, and the pluralist notions of justice, to mention but some of them. James Crawford has expressed the view that the international rule of law, as analogous to the domestic concept, is conditioned by certain facts, notably the absence of legislative powers such as it exists in domestic legal systems, and the correlative need for many decisions to be made by consensus of states. For similar reasons, Hisashi Owada calls for a reconceptualization of the rule of law in the international context, even though certain elements of the rule of law remain so essential that they should be applicable also in interstate relations, the same way they do in the domestic realm. The question of the rule of law as a legal concept and as a political idea is reflected throughout the debates at the UN. In 2004, the concept was given substance when the Secretary General attempted to define it in a long assertion that I quote, "A principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. It requires as well measures to ensure adherence to the principles of supremacy of law, equality before the law, accountability before the law, fairness in the application of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency." This long definition proposed by the Secretary General, the UN Secretary General, speaks we don't know exactly if he intended to propose a formal definition, but in fact the way in which it defined it speaks more to the rule of law as it is understood at the domestic level and not at the international level. While no formal definition of the rule of law had been agreed upon by member states, the discussions began to gain importance in 2005 when the World Summit was held. The normative relevance of the rule of law was becoming recognized as an increasingly relevant reference point against which the behavior of states is assessed under international law. In September 2012, the UN General Assembly held a high-level meeting on the rule of law at the national and international levels. In the resulting declaration, member states avoided very much to define the rule of law principle at the international level, as well as using language implying that the rule of law is a binding principle of international law, and dedicated themselves to support efforts to uphold the sovereign equality of all states, to respect their territorial integrity and political independence. In the subsequent rule of law debates in the 6th Committee of the UN General Assembly, some light was shed into understanding how states perceive the international rule of law and its core requirements. For instance, cases such as the ICJ case or judgment on the Colombian-Peruvian asylum case was quoted, studying the attitude of states before this principle, or in the the ICJ case on the electronic circular case, when doing some considerations concerning predictability and consistency. In the 6th Committee also, but in CELAC or the ASEAN, much emphasis has been put on the predictability of rules of the international law as an element of this principle. Therefore, at least in these forums, no less than 117 states have expressed the view that predictability or certainty are elements of the international rule of law. Concept principles, it hasn't been clarified. All statements point to the importance of consistency in the application of legal rules for the international rule of law. Double standards and claims of exceptionalism in the application of international law have been described as unacceptable and as promoting politicization of the law. Instead, a number of states have called for fairness and equality in international law. In this context, the Asian and the African group have described consistency as an element of the international rule of law. Also, the continental shelf case opposing Libya and Malta, the court, the ICJ, found that the justice of which equity is an emanation is not abstract justice, but justice according to the rule of law. The requirements of consistency and a degree of predictability are not deduced from abstract justice, but from a rule of law in international law. In contemporary academic literature, the rule of law has been described as the raison d'être of international law and as the single most important goal of the international system. But, as Collins has put it, how are we to understand this recurrent reaffirmation of the rule of law ideal, given the constant frustration over its realization in practice? Christopher May has recently defended the idea of the rule of law as a kind of global common sense, which functions as such only because a certain indeterminacy as to its core meaning exists. Given that international law is a socially constructed form of institutional practice, to dismiss the relevance of the international rule of law would seem to undermine the coherence of this practice as it is understood by international legal participants themselves, a group which include states, international lawyers, international organizations, and other relevant actors, why not national societies of or for international law as well. One still faces a further difficulty in giving a plausible account of the international rule of law. This difficulty comes from the simple fact that the question of what is important or valuable about international law is itself a matter about which the modern discipline appears fundamentally conflicted, revealing opposed understandings of the role and function of legal rules in the conduct of international politics. From amongst these many understandings, there emerge two plausible, convincing idealizations of an international rule of law. A more rationalist, functional or instrumental understanding on the one side, a more formal, procedural and fundamentally pluralist understanding on the other. We might say that the international rule of law is an ideal that is intrinsic to the systemic integrity of international law as a decentralized legal order. It subsists in the idea of legal association between political actors related to each other formally, rather than because of shared values or ends. Accordingly, frustration over the realization of the rule of law, the story of hope and frustration, skepticism and disenchantment appears. Insofar as international lawyers increasingly grapple with the problem of the accountability of global governance, institutions, and the rule of law features as an important critical counterpoint in coming to terms with this phenomenon. For as long as international law has been thought of as a broadly consensual institutional practice, its core doctrines, sovereignty, self-determination, statehood, sources, etc., assume something like the rule of law as the basis of mediating the individual sovereignty of states. As such, the rule of law has entered international legal imagination as a necessary presumption of the very idea of international law, the very idea as an institutional practice, the legitimacy of which is related to the self-authorship, non-arbitrariness, and autonomy or objectivity of international legal rules. However, insofar as this understanding has always seemed somewhat problematic when applied at the international level, where the decentralized institutional structure of international law seems to undermine its autonomy and objectivity in practice, the rule of law emerges also as an equally important reformist ideal, stressing the important work to be done to complete such a vision of ordered international relations. According to what has been said, first, the rule of law is inescapably important to the coherence of modern international law, both as an idea that structures international legal practices and normative expectations, and as an ideal in the self-understanding of international law as a kind of collective project. Second, the concept of the rule of law, as it has developed in the domestic context, cannot easily be translated to the international legal order due to the structural differences perceived and somehow justified in the unique circumstances of international relations. The rule of law functions as the basis of association in international relations. On these terms, it represents a more substantive commitment to legality as a counterfactual abstraction of the international legal relationship, an ethos of playing by the rules. The point is deeper than, in words of Collins, the point is deeper than that the sovereign states of the international order find themselves always entangled in international law as they consider how best to advance their interests. It is that they are themselves creatures of international law, and to maintain their status as sovereign states, they must treat as binding the law that constitutes the jurid community of which they are a part. Hence, when one state raises a question about the legality of another's action or proposed action, that state must accept the onus of justifying its action as having a warrant in a reasonable interpretation of the law. The rule of law represents an ideal expression of a shared moral commitment to a system of common rules, the authority of which stems from its commitment alone and not from any sense of higher purpose or instrumental benefit. The rule of law is also an institutional ideal, we have said, the emergence of a global governance. The brief account of the international rule of law, this brief account of international rule of law reflects the collective experience of the modern discipline in trying to work out a feasible and legitimate system of positive laws as a means of structuring international political relations.
Thank you, Professor Ana Salinas de Frías. We appreciate your reflections, the overview you have provided us on the ideal of the international rule of law. Thank you so much.